Good afternoon, everyone, and welcome to the first webinar in our English property law series relating to real estate development. My name is Neil Rainey. I'm a partner in the English property team at Shepherd and Wedderburn's Edinburgh office, and joining me this afternoon is my colleague Emma Carmichael. Before we start the webinar, we have a few housekeeping points to run through. As ever, just to keep background noise to a minimum, we have placed each of you on mute. You're at liberty to use the chat function throughout the presentation to post any questions that you might have, and we will do our best to answer them at the end. Please do include your email address when asking a question so that we can respond by email if there is not enough time once the seminar has concluded.
Today we will seek to give you an overview of the different sorts of agreement you may encounter in development transactions, and we'll take a look at a case study and highlight with reference to that a number of issues that commonly arise in a development transaction. Most people will recognise development when they see it. It may be large scale and involve bulldozers and large cranes, or it may be much smaller scale and involve a few builders and tea breaks. This breadth is reflected in the Town and Country Planning Act 1990, Section 55(1), which, so far as relevant for present purposes, defines development as the carrying out of building, engineering, mining, or other operations in, on, over, or under land.
Whilst the complexity of development work on the ground can vary tremendously from project to project, it is not the case that the underlying legal framework will vary in the same way. Large developments can be procured with a simple development agreement, and on the other hand, smaller value projects may have third-party funding, which makes the arrangements more involved. For example, this slide shows a simple contractual structure. This could arise where an owner-occupier refurbishes its commercial premises. There is no need in this case to buy the land, and the owner will fund the development from its own resources. The developer or building contractor, which need not be the same person but they can be, agrees to design and carry out the refurbishment works. There is no particular need for any subcontractors, and no separate professional team is appointed.
At the other end of the spectrum, we might have a more complicated development contractual structure, which could look like this. This structure includes funding from both a third party, either an institutional fund or a bank, debt or equity from the shareholders of the developer, hedging arrangements, the contractual arrangements with the building contractor and professional team, which may include an architect, a project manager, structural engineer, mechanical and electrical engineer, and others, and the property arrangements that may be needed to purchase the land and put in place pre-lets or pre-sales to ensure that there is an income stream or a capital receipt due on completion of the development. Whilst we will touch upon each of these areas in the webinar, we intend to return to the question of the red construction issues and the blue finance issues in the second and third webinars of the series.
As you will recall from the two contract structures on the previous two slides, one of the main legal documents which would be common to the majority of development projects is the development agreement. Development agreements are entered into primarily in order to regulate the relationship between the various parties, the landowners, property developers, funding institutions, and prospective tenants. There are various types of development agreement. But broadly speaking, the terminology you may hear used includes a straightforward agreement for lease, a development management agreement, a forward purchase agreement, and finally a forward funding agreement. And we will take a look at each of these in a little more detail in a moment. Which form to use depends, of course, in each case on the nature of the particular project transaction and how it is to be funded. At their heart, they are all commercial contracts which seek to govern each party's obligations relating to the project and to balance everyone's risk and reward. developers will invariably seek to lay off their risk onto the contractor and professional team.
You may hear reference to speculative development agreements. Whilst the underlying commercial terms may differ if a development is speculative, the same type of development arrangements referred to previously will still apply. The difference is that there is no third party contractually committed to occupy the development when the building work is completed. This increases the risk on either the investor, if committed to take the completed development without a secure income stream, or the developer, if no development fee is paid until an occupier is found.
Now, one of the more common development agreements is the Development Management Agreement, or DMA. At its simplest, this is an agreement under which a developer agrees for a fee to project manage a development project. It assumes little risk, and this is reflected in what it is paid. Some DMAs will have more aspects of a fully blown development agreement, and others will be closer to a simple professional appointment. But unlike a typical professional appointment, all or a substantial portion of the developer's fee may depend on successful delivery and possibly also on successful disposal of the completed project. The landowner will retain the top slice of the profit, and the balance is then distributed in a manner that will hopefully generate a return for both the investor and the developer. Where the DMA falls on this spectrum will depend on the control that the landowner has over the appointment of the contractor and professional team, and also on how much control it has over the end results of the project. These matters are significant when considering what risk each party bears and what reward there should be for the developer.
Turning now to an agreement for lease. This is the simplest form of development agreement. In it, the developer landowner agrees with a third party that it will carry out certain works, and upon completion of those works, the third party will agree to take a lease of the premises that have been created by either the whole or a part of the development works. It is worth noting that an agreement for lease may form part of the wider contractual matrix of the development. For example, we refer to agreements for lease in our complex contractual structure. If they are procured by the developer, who has already entered into a development agreement with the investor, then this means that the development should be income producing shortly after it is completed.
The third type of development agreement is a forward purchase agreement. This sets out the terms on which the property will be sold by the developer to the purchaser, who will generally be an institutional investor or fund. The developer and the investor fund will exchange contracts for the sale of the completed property at an early stage in the development process. And with a forward purchase agreement, the purchaser does not agree to provide the construction finance, but instead pays the purchase price when the project is completed, and usually after it has been let, at least to some extent. The developer will fund the construction costs from its own resources or by obtaining short-term loan finance, which is then repaid from the sale proceeds. The price to be paid may be agreed in advance as a fixed amount, or alternatively, it may be related to the value of the completed development as calculated at completion by capitalizing the total rent roll on certain assumptions.
Achieving practical completion is often critical in a forward purchase agreement, and becomes even more so in circumstances where the market has changed since the agreement was signed and the price to be paid was agreed. After the financial crash in 2008, we had experience of many investors seeking advice on how they might escape deals that were no longer financially attractive, and also of developers seeking advice as to how to ensure that all the preconditions to completion of the sale were fully satisfied, to deny the investor the chance to wriggle out of its contract.
In contrast to a forward purchase agreement, in a forward funding agreement, the investor provides finance to cover all the costs of the development as it progresses. Under this arrangement, the developer may settle for less profit but less risk than if the developer had developed the property with its own money and then sold the completed investment. The investor takes on some risk, but hopes for a lower purchase price and a higher yield than if it had waited until the development was built and let before committing to buy it. The developer will receive a profit payment once the development is completed and, again, as noted above, usually let. This may be calculated as a percentage of the value of the completed project, having deducted the costs of the completed development. Now, in a typical forward funding agreement, the developer immediately transfers freehold title to the investor, which is then reassured that it is advancing money to be spent enhancing its own land, and the developer then has the right to draw down money from the investor to pay for the costs of the development. And the costs are usually paid by the investor against monthly invoices from the contractor and professional team up to an agreed maximum commitment. Any costs beyond the maximum commitment will then be borne by the developer. Further, the developer will agree to build the development in accordance with an agreed specification pursuant to the agreement.
So why does the distinction between the types of agreement matter? The developer and the investor should each understand what risks it is taking on and the rewards for accepting those risks. It is important to align the two. The idea for this series of webinars came from a development project that we were asked to review for a bank. An investor had assembled a site, buying in parcels of land from various owners. The investor had appointed an experienced developer to design and build a business park. When initially acquiring the site, the investor had used bank funding and the bank had a charge over the site. The investor had an option to convert the facility used to acquire the site to a development finance facility. In order to exercise its option, it required the bank's consent to the development agreement. The investor proceeded to agree and exchange the development agreement with the developer, subject to various conditions precedent to the commencement of development, one of which related to the bank's consent. We were asked to review the documentation and advise the bank on whether the development agreement was satisfactory, bearing in mind the bank's intention to provide development finance. Our review suggested that there were a number of significant defects in the development documentation, and we were instructed to negotiate variations. Our main conclusion was that the investor thought that it had appointed the developer to take on the whole risk of the development and was paying it accordingly. The developer had essentially provided that its role be limited to that of a development manager and had passed back various development risks, but it was still being paid as though it was taking on those risks.
There are various matters that require to be addressed in all types of development agreement, and we thought that we would highlight a few issues by reference to this particular case study. As you will appreciate, some of the details have been changed, but the underlying issues demonstrate real problems that we encountered. It is entirely usual to see covenants in a development agreement that are designed to ensure the development is of suitable quality. More specifically, the covenants normally deal with matters such as workmanship, materials, which as an aside would certainly not be Lego, and compliance with any statutory requirements. The developer would also covenant to carry out the development in accordance with all planning agreements. Furthermore, a well-advised developer will also be mindful that whatever obligations it gives to the investor should be capable of being passed on to the contractor and professional team in whatever market conditions prevail at the time. When reviewing the development agreement in our case study, the investor had secured no rights to approve the planning application for the development, and accordingly there was little scope to approve the planning permission and what would ultimately be built. Nor did the investor have any right to object to the terms of any planning agreement, and was simply required to sign whatever document was placed before it. So whilst the developer could therefore argue that it was complying with planning and therefore delivering a good quality product, the product was potentially not one that the investor wanted. The developer had also imposed an obligation on the investor to employ the building contractor and the professional team, and assume direct liability accordingly, on such terms as the developer determined at its discretion, with very limited ability for the investor to object. This allocation of risk back to the investor was entirely inconsistent with the fee structure the investor had agreed with the developer.
We will now look at a number of factors that can influence the timing of a development. One of these is the design process itself. On some schemes, the negotiations between developer and purchaser may be proceeding on the basis of an outline design, because the developer is unwilling to spend time and money on the detailed design until contracts have been exchanged and have perhaps become unconditional. In such circumstances, there may be delay whilst the parties agree the final design. The development agreement may also need to make provision for changes to be made to the design, and will need to state who can initiate that process and who will pay for the cost of any variations. Target dates should be set for satisfying conditions precedent to the commencement of development and completing the development works. With regards to the conditions precedent, it should always be agreed who will be responsible for satisfying them. It may be appropriate for the developer to obtain planning permission and any other necessary consents. If the site is currently occupied, it may be sensible to put the obligation to secure vacant possession on the landowner or investor. In agreeing a target date for completion of the works, the developer should ensure that a buffer period is built into this date to avoid having to approach the investor for extensions of time. In addition, the developer may seek to agree circumstances in which target dates, and possibly the long stop date, can be extended for circumstances outside the control of the developer.
The parties should also seek to negotiate a long stop date by which all conditions precedent are satisfied, and also by which the development works are completed. As a rule of thumb, the long stop date for completing the development will commonly be at least twice as long as the period from commencement to the target date for completion. An even longer period may be justified in circumstances where, for example, there may be complex planning restrictions. It is worth noting in passing that on a forward purchase, there may be further conditions precedent to the investor receiving a handover of the development. The investor may wish to see one or more tenants obliged to take a lease or leases of the completed development on institutionally acceptable terms, and should ensure that there are suitable controls around disposal. Now, in our case study, the investor, again, had very limited control over how the developer disposed of the completed phases of the development, whether that was by way of grant of long leases at a premium or by way of grant of leases reserving open market rents. And this could have had a detrimental effect on the final value of the development.
If the developer performs, then at the completion of the development, the investor will pay a development profit or fee to the developer. In our case study, unfortunately, the investor has little or no control over the developer's performance, with the result that the development fee proved too easy to obtain. In particular, the developer could incur significant development costs without prior approval of the investor, which the investor then had to reimburse, and there was no entitlement to object to them, even if they had been increased unnecessarily by acts or omissions on the part of the developer. The investor had limited rights to terminate if the developer became insolvent, and if there was a material breach which was not remedied after a rather cumbersome remedial procedure had been implemented, which could have delayed the project by some months. Furthermore, in our case study, the term of the development agreement was for more than 10 years, and the investor had no right to terminate on a no-fault or at-will basis. This may be desirable if it transpires that the necessary consents to start the development are not likely to be obtained.
So when would we expect a development agreement to contain rights of termination? Well, first, where preconditions to commencing development are not satisfied by the relevant long stop date. This would normally be a mutual right, but there may be some argument as to whether a party who was responsible for satisfying a particular condition should be allowed to terminate if that condition has not been satisfied. I would also expect to see a right of termination arising where the investor and possibly also the developer becomes insolvent. Care should be taken, obviously, to define what we mean by insolvency in this context to ensure that we catch all relevant insolvency events. It's also standard for a breach of obligation by another party to give rise to a right to terminate. This may be qualified by reference to materiality or to the defaulting party being given time to cure the breach, assuming, of course, it can be remedied. And as Emma has already said, a no-fault right to terminate is also often provided for in circumstances where there is, for whatever reason, no appetite for continuing with the development. This latter right of termination may be a difficult provision for the developer to accept, unless it can only be exercised before the developer has incurred significant expense, or on the basis that the investor reimburses all or an agreed proportion of the costs it has incurred.
The investor may also wish to negotiate a provision for liquidated damages to be payable if the developer misses a target date. Liquidated damages are a fixed or predetermined sum agreed by the parties to a contract to be payable on breach by one of the parties. Care should be taken to avoid the liquidated damages payment constituting a penalty. In such circumstances, the obligation to pay will be unenforceable. The level of liquidated damages can often be contentious, with developers looking to pass on the liability to the building contractor, who will have its own view as to what might be acceptable. It should be borne in mind that the contractor will price accordingly and may well require a longer development programme. Also, contractors are increasingly willing to agree liquidated damages as they see them as operating as a cap on their liability.
There are various ways in which the developer can be rewarded for performing under the development agreement, and it will come as no surprise to you to hear that the provisions relating to how the developer's return is calculated is often the subject of intense negotiation between the parties. Now, we have already covered some of these earlier in our talk, but in broad terms, the types of fee that we are used to seeing are, first, a lump sum fee payable, which may be payable by installments on key dates or upon completion of construction milestones. We've seen a percentage of costs borne by the owner in relation to the development, and also we can have an arrangement whereby a percentage of the proceeds of sale and or other sums of a capital or income nature received by the owner in relation to the development are used to calculate the developer's return. An amount based on the profitability or success of the development is also commonplace, and that usually only applies where a certain threshold or hurdle rate has been achieved. Or you could see a combination of all or any of these.
In our case study, the investor had little control over the development costs, and the developer was to be rewarded by reference to a percentage of the development costs together with a percentage of the profits. The investors' and developers' interests were therefore unaligned. The developer benefited whether the costs or the profit were high, and the investor could have suffered if there was a budget overrun.
As this might suggest, a detailed understanding of development costs is also crucial. The development agreement should contain provisions providing for the ascertainment of what constitutes a development cost and who is responsible for paying it. In a development management agreement, for example, there would be a requirement to prepare a development cost budget in relation to the development. And this is usually prepared by the developer and is subject to owner approval. And the budget will usually focus on the anticipated development costs for the next 12-month period. Two of the most important development obligations are then to procure that the development is completed within the agreed budget, whilst following an agreed development program. Alternatively, if the developer is being paid by reference to a percentage of the profit only, the investor may have less interest in the cost of development and more interested in ensuring that the design and quality of construction are of a high standard.
Putting together the different elements of a development site can turn into a complex jigsaw, and getting the pieces to fit at the right time can be difficult. Issues that might arise on site assembly include title investigation to establish whether the site is subject to rights, for example rights of way or drainage, or covenants, for example covenants not to use the property for anything other than agricultural land, which might prevent development. It may be possible to design the project around such site restrictions, or it may be necessary to establish the party with the benefit of the restriction and negotiate a release. Other issues that might arise on site assembly are negotiating appropriate purchase agreements, either conditional where required or option agreements, and associated funding agreements to bring each part of the site under the control of either the investor or the developer. Other issues include dealing with rights to light issues, a very topical subject at the moment and the subject of a recent Law Commission report, negotiating crane oversailing licenses, agreeing overage or clawback provisions, negotiating indemnity insurance in respect of title defects or right of light issues, and negotiating planning agreements. This can be problematic in terms of timing if there are multiple landowners who are separately represented. In our case study, we soon realised that the development agreement failed to address various title issues, including certain third parties having the benefit of overage. These payments had an effect on the profit that the investor would realise from the completed development, and we needed to take this into account in renegotiating the calculation of the developer's profits.
The investor should always consider what recourse it may need against the developer, the contractor, the professional team, and indeed subcontractors. In our case study, the developer gave the investor no control over the terms of the building contract and appointments, nor indeed over who was appointed. This was clearly unsatisfactory. In addition, there was no obligation on the part of the developer to obtain warranties in favour of the funder, and nor was the funder's likely requirement to have step-in rights anticipated. And this was particularly unusual given that the development agreement specifically recognised the need to get the investor's funder's consent. So the investor should ask to see evidence of the contractor's all risks policy and the professional indemnity insurance held by each contractor and professional. Consideration should be given as to how the proceeds of the contractor's insurance of the works are to be dealt with, and this will determine whether the insurance should be effected in joint names and whether the investor should be first loss payee for proceeds in excess of a specified amount. In our case study, the development agreement surprisingly did not require the developer even to maintain professional indemnity insurance. There will come a point in time, of course, when the developer will wish to be released from its obligations under the development agreement. Typically, this will happen after the developer has not only practically completed the development, but has delivered collateral warranties to the investor, and a period after practical completion during which defects are to be remedied has expired. Timing of this release is really a commercial matter for the parties to negotiate. Our forthcoming construction webinar will discuss matters relating to completion of the development works and further issues relating to recourse and risk mitigation and allocation.
Given the possible complexities arising out of the development project, we recognise that all of the parties will have a number of professional advisors, including lawyers. Within each legal team, there may be input from a variety of specialists, including property, construction, finance, tax, planning and environmental. How this input is managed is important. Experience suggests that legal advisors should be involved as early as possible in the process, even if you need to agree some form of contingent fee for initial advice. Development projects are costly, but with some forward planning, it may be possible to manage your legal spend and allocate work that might otherwise be passed to your lawyer, for example, seeking approval for plans, to another member of your team. There is often considerable value in having the lawyers for all parties working together in a collaborative manner to discuss possible but still realistic risks and how they might be mitigated to the satisfaction of all, to ensure that the parties are not saving up trouble and greater legal expense midway through the project. As this slide suggests, when we think about what might go wrong, we're more likely to design something that goes right. This collaborative approach was missing in our case study, and the result was a very one-sided agreement that ultimately benefited no one.
So to conclude, we have sought to draw your attention to the importance of ensuring that the risk which each party takes on in any development transaction reflects the reward that it is going to receive, and that a fair balance is struck between all of the parties involved. As evidenced by our case study, although a very one-sided agreement may appear beneficial at the outset of a transaction, this will often turn out not to be the case. In our case study, the time and cost involved to both parties in renegotiating the documentation was substantial, and the delay, unfortunately, coincided with the downturn in the market, which then affected matters all the more, to the extent that the development finance facility was never forthcoming. So that concludes today's webinar, and hopefully we have managed to highlight at least some of the issues encountered in the context of development projects. There would normally be an opportunity for questions to be asked, but I am just noting that we have overrun our allotted time a little. So thanks to those who have already asked a question. If anyone else would like to do so still, please do use the chat box function on your screen, and either Emma or I will endeavour to answer all the questions later in the day. So just to remind you, this webinar is the first in a series of webinars dealing with real estate development. The second, which is scheduled to run on 18 June, will deal primarily with construction aspects of real estate development, and our final webinar on 20 July will focus on real estate finance, including the key considerations when taking out loans on development projects. So thank you very much for your attention, and have a very pleasant afternoon.